Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Limitation Act. Friends, in the Limitation Act, I told you the brief salient features. Then what is sufficient cause, what is not a sufficient cause. Today, we are going to discuss the important topic, that is law of prescription, limitation for prescription. Before that, please read the definition of Limitation Act 1963, right? Section 2J gives the definition for period of limitation. So means prescribed for any suit, appeal or application. Then what is prescribed period? Law of prescription. Prescribed period means the period of limitation computed, that is calculated in accordance with the provisions of this act. Now going to section 25. You will acquire the lands. Before that, please remember, possession is 9/10 of ownership. You will get only possessed rights. So section 25 of the Limitation Act deals with the acquisition of ownership by possession. Acquisition of ownership by possession. Please remember, these are only possessory rights. Easement, it is otherwise called as easement by prescription. What is doctrine of prescription? If you are in continuous uninterrupted possession of a particular property for 12 years, adverse possession, 20 years, ownership by possession, 30 years, if it is a government land. These periods you have to remember. Section 25 says, where access and use, accessibility, way and use of any light, air or way to any building, any area. If it is enjoyed peaceably, that means without any interruption, as an easement. ఈజ్మెంట్ రైట్, బళ్ళ బాట ఉంటాయి కదా పల్లెటూరులో, అలాగే పలానా బావికి అందరూ వెళ్ళి నీళ్లు తెచ్చుకోవాలని. దీస్ ఆర్ ఆల్ ఈజ్మెంట్ రైట్స్. ఈజ్మెంట్స్ యాక్ట్ 1962, you know. So if the continuous possession without any interruption for 20 years or 30 years, 20 years in case of private property, 30 years in case of government property, such right becomes indefensible right. But a limitation period of 2 years is also given. So if you want to institute a suit, you have to file only within 20 plus 2, 22 years. Later, you have no right. Your period of limitation is gone. That means the other person will acquire the right due to prescription. So you remember all these points. The section is elaborate, but point-wise I have cut into pieces, sections. Now we are going to discuss very, very important case laws. Number 1, Jogeshwar Gayan versus Motiram Bora and others, 2004. I explained in the class also. So this is suit for declaration of right to passage. Some person, no doubt here the dispute is there. Some person, that is this is Jogeshwar Motiram Bora, he has constructed a kacha house or temporary house in the passage. But these people, they have been enjoying the same for 20 years. He claims that he has raised objection. It is his land. He wanted to construct a house. But Honorable Court held that evidence showed that he constructed a house in the year 1977. But prior to that, continuous 20 years of time, it was an agricultural land and the people have been enjoying the rights. So mere construction of a kacha house, that too with the intention of obstructing them, is not correct. He should have filed a case. Without that, you cannot morally obstruct him. It cannot be taken into account. రెండవది మీ క్లాస్లో చెప్పిన ఉదాహరణ, అన్నదమ్ములు తగాదా, ఇక్కడ కాకి అక్కడికి వెళ్ళడానికి లేదు, మధ్యలో ఒక గోడ కట్టుకున్నారు, కానీ ఈ గోడకు ఉన్నటువంటి కిటికీ తీయకపోతే తమ్ముడికి గాలి రాదు, వెలుతురు రాదు, నో వెంటిలేషన్. అలాగే 20 years ఎంత డిస్ప్యూట్ వస్తే ఈజ్మెంట్ రైట్స్ వస్తాయి. దిస్ ఈజ్ స్టేటెడ్ ఇన్ రామ్లాల్ వర్సెస్ ఫాగా మాథో, PHAGA, ఫాగా మాథో, MATHO, MAHTO, 1971. In this case, the court considered the right of easement acquired by prescription because the light and air were coming through the dedicated window if it is open. And they have been enjoying the same for the past 20 years. Since once again the disputes cropped up in the next generation, second generation ku vacharappatike, it cannot be closed. It has to be kept open because they have got prescriptory rights. Another case, Munnalal versus Bhuri Bai. Munnalal versus Bhuri, BHURI, 1975. So this is a case which highlighted the principle that easementary rights can be acquired by uninterrupted, continuous use. It will continue unless and otherwise filed by OP. You have to institute a civil suit. Some OS has to be filed. అంతేగాని mere obstruction is not sufficient. సో కాబట్టి ఏదైనా ఆన్ రికార్డ్ రావాలి అని ఆ కేసులో కూడా చెప్పారు. These case laws are very, very important. You may get a question on this prescription, particularly section 25. So here 26లో, if it is the case of a reversioner, అంటే ఈయన చనిపోయిన నాకు వస్తుంటారు, or servient tenant, then the period of 2 years is extended to 3 years. Section 27 ప్రకారం then he will have an indefensible right. Nobody can question him. Okay, with this I am concluding. Thank you very much.